tea or coffee and had a chance to stretch out your legs. Just want to make sure that I am on and that you can all hear me. Yes, it seems that way. I haven't seen anyone say no, so okay, great, thank you. So we are almost at the end of the day and almost at the end of NetThing and at the end of the week. I hope you've all found these past 2 days a lot more invigorating, or maybe not. I hope that you find your day-to-day work just as engaging as the last 2 days have been. But thank you for joining us for the final panel of NetThing 2022, and I hope that you're going to find this last session just as interesting. So I will be moderating this session, and I want to start by acknowledging the traditional owners of the different lands that we all joined from today. I come to you from Darug land, and I pay my respects to elders past, present, and emerging, and extend my respects to all First Nation peoples joining today. I just heard that my audio is breaking up. Is that still the case? Okay, I did test it and it was fine. It's always the case, isn't it? Okay. No audio at all. Okay. Is this better?
Much better.
Much better. Okay, thank you, Christiane. All right. Okay, great. All right, we'll continue then. So as I said, today we will be discussing defamation law for ISPs, internet service providers, and other internet intermediaries, which is a very live issue that faces the internet sector today. You know, with recent High Court decisions like Google and Defamation, and the Coalition of Attorney General currently conducting their review of amendments to the model defamation provisions, which includes specific provisions pertaining specifically to the internet industry. We have seen a range of different perspectives on how to legislate reforms that manage the balance between protecting perspectives on how to legislate reforms that best manage the balance between protecting the reputation of the individual end users, as well as the respect of, our freedom of speech, but also placing appropriate responsibilities on industry and ensure the smooth running of the internet. And the accessibility and the unique nature of the internet means that there is a much greater volume of potentially defamatory material being published online. And it's also raised a new question of how we understand the basic legal principles that underpin defamation law when it is applied to the online world. And this question actually points to a broader consideration of what extent to which internet intermediaries should be liable for what happens on the content layer of the internet, which is a phenomenon that the industry has increasingly seen being expanded. For example, intermediaries being responsible for copyright material that's being hosted online. So the aim of the discussion today is to unpack this very nuanced and complex question of how to strike that appropriate balance and implement effective and appropriate laws. And joining me today, we have Sunita Bose, the Managing Director of Digi, Christiane Gillespie-Jones, the Director of Program Management at Communications Alliance, Daniel Joyce, an Associate Professor at UNSW Law and Justice, as well as a member of the Allen's Hub for Technology, Law and Innovation, John Morris, Principal of US Policy and Advocacy at the Internet Society, who I do want to especially thank for joining us today from the United States, where it must be extremely late where he is at this time. And unfortunately, Sophie Dawson from Bird and Bird will no longer be able to join us, and my best wishes to Sophie, as well as Christiane, who I understand is also feeling a little unwell, but thank you still for joining us. So without much further ado, we will get started. And firstly, I'd like to ask Daniel for a brief explanation of the publication element of defamation law and how this intersects with online defamatory material.
Look, can you hear me all? Thank you very much, Sophia and all the organisers. Look, publication, I guess the big picture is that publication is one of three traditional elements. There's now a fourth element, serious harm, that's been introduced, but it's publication, identification, and is it like meaning, basically, is the matter defamatory? And publication has been one of the really important areas to consider with these internet and digital media contexts, alongside also whether there should be some new defences crafted or whether some of the existing defences should be available. And I guess it's quite helpful. I mean, it's quite a sort of technical term, publication, and it's a little surprising, I think, outside the rather esoteric ecosystem of defamation law, to understand how broadly it has traditionally stretched to. So I'm going to just read two different passages from the recent Voller decision, which I think best capture in a clear way what is actually a very sort of vexed area, at least in terms of application. So in the Triculia case, the High Court say, look, the principles are quite clear. It's pretty hard to apply them in their context. And I think that's where much of the contention emerges. So the first aspect of publication that I think needs emphasising is that it's bilateral. So publication is the actionable wrong in the sense that harm is sort of lies at the heart of defamation as a tort, and the perception of the law is that the harm is caused on receipt or comprehension of the defamatory statement or material. And so in the older cases, like Dow Jones and Gutnick, for example, there was the sense that, look, publication is not the upload by itself, it's the download, and this bilateral kind of context of kind of communication and then receipt of the communication that is important. And I think that does create some challenges for us. So the High Court's position at the moment is that publication may therefore be understood as the process by which a defamatory statement or imputation is conveyed. So it's this idea of conveying the defamatory matter. And then there's this question of, well, who might be captured within that process? So is it just sort of the originator of this material, or the author, if you like, to use that sort of traditional kind of conception, or might it extend to a wider range of actors? And traditionally, it has extended to a wider range of actors. So you'll be familiar that in a traditional media context, for example, it's the company, it's the journalist, it might be the editor and the producers potentially, but also could be the sources that they've relied upon, for example. So in terms of how the High Court from Voller on, and I think this is held with the Defteros case, have kind of understood that aspect of I guess, level of kind of participation, what's required for publication. They've basically said, look, consistently with the approach in Triculia, and then that in itself draws on the older case of Webb and Block, that publication, which is understood strictly, is understood to say that a person who has been instrumental in or contributes to any extent to the publication of defamatory matter, that they are a publisher. And all that is required is a voluntary act of participation in its communication. Sometimes that gets referred to as intention, but it's not intention in the sense of they intend for someone to be defamed or have that level of knowledge. So in some ways then what we see with Defteros, which is a case about Google search and hyperlinks, is that we have this quite broad and rather strict approach to publication hitting up against a kind of policy question, which is, look, hyperlinks and the provision of a hyperlink through Google search without anything more, should that really be seen as a contribution to the publication of the defamatory matter that might be contained within that hyperlink. And there does seem a little bit of pushback there. So we are still, I mean, the principles are clear, I guess, but after Defteros, I think they're a little less clear. And some of the judges in Vola, which is the case prior to Defteros, some of them apply the principles that they've agreed on in different ways in Defteros. So Gaigler and Gordon, who gave a joint judgment in Vola, split off and take a different view. Gaigler says, look, hyperlinks should not be regarded in that sort of sense of being, publication being incurred. But Gordon is less convinced. So it's an interesting point we're at. I hope that hasn't taken too much of our time, but I do think it's a fundamental issue that really has also triggered some of the reforms we're going to discuss.
No, thank you so much, Daniel. And I agree that I think understanding what that basic legal principle is and how we understand it in the context of the issues or of the cases that come about today is critical in understanding where we go in terms of reforming the law going forward. And I suppose that brings us in quite nicely to the next question, which is open to all the panel members, which is, are defamation laws specific to the internet industry necessary, or is Australia's current regime via the uniform defamation laws coupled with the common law examples that you briefly spoke about, Daniel, sufficient? And I might direct that question first to Christian.
Hi, good afternoon, everyone. I hope you can hear me well. Say if you can't. I should profess that I'm not a lawyer, and I wouldn't even claim that I'm a defamation expert. So, but I deal with defamation for Communications Alliance and these related issues. And thanks very much for that explanation, and it is exactly what I looked at actually in preparation for this talk here, or for this discussion. I personally shy away from overly specific regulation and legislation for different subsections of industry or industries in general. I think overall they tend to be quickly outdated and don't stand the test of time. And what we just heard from Daniel was, I think, going in that direction already, because we see the shift already in thinking over time as to what communication may be, how it could be interpreted, what it means. Also, I think it's fair to say that in the past, communication might have been a slightly, although complex, but a slightly less complex aspect to interpret in the offline world. It is certainly more complex in the online world. There are more players involved. There are more different technical layers that are involved in communication and determining whether a communication has taken place or a publication has taken place. First as a publication, and then in determining whether a publication has taken place, we look at whether a communication has taken place. So yes, it has become more complicated. Having said that, I would say that overall, with the current amendments to the model defamation provisions as envisaged in principle, whether we are now going for alternative A or B and what comes out of it, but with the major tweaks, let's call it, that we are making or seeking to make in this process, and the, I think, increasing case law that we will be seeing, I think the combination of the two, common law plus the current uniform approach, I think that will serve Australia well also in the future, as long as we strive to, and which we are currently doing, to take a technology neutral approach as much as we can, which is quite difficult, but I think we are striving to do that, and that will serve us well. Let's see whether we manage to do that and still do justice to the different types of technologies that are out there.
Thank you, Christiane. Sunita, did you have any thoughts on this question?
Hi, Sophia and everybody. Thank you so much for the opportunity to share my views. I hope everyone can hear me okay, but again, shout out if you can't. I'm coming to you from Gadigal land, and yeah, really appreciate the opportunity to be part of NetThing. Look, in terms of the question, do we need laws specific to the internet? I would say, yes. I mean, the internet is where our conversations play out, and the internet obviously adds a level of dimension and scale to the magnitude of those conversations. So yes, I think that the fact that the reform process has had this stage too, that is focused on internet intermediaries, I think there's a weight of considerations and questions that necessitate that sort of focus. I think, so for those who don't know me, I'm the Managing Director of Digi, the Digital Industry Group, and this is an industry association that works with the internet industry. But I think the point I want to make, despite representing the internet industry, is that I think that greater clarity through reform proposals in this area can actually serve to benefit not just the internet industry. It's for the millions of countless number of people who share their voices online. If you're someone who puts a review of a product or service that you use, or if you post a comment in some sort of community group or parenting group, or you post a message as a university student in an educational forum, these defamation laws will affect you. It reflects that sort of content. And I think the second point I'd make is that this is not just sort of an internet industry or tech industry challenge, it's also the entire internet, entire kind of business community, because every company has a digital presence, has a website these days, and arguably every business is using some sort of digital tools to manage their business or to enable some sort of customer interaction. So I think it's really important to give a lot of consideration to all of those interactions and how defamation law serves to protect the many different interests in that entire ecosystem. We need to get this law right to provide legal clarity and protection for, content authors, defamation claimants, all of the companies that are part of that ecosystem. It's also a really great opportunity to reinforce certain principles, that fundamentally, I'm of the view that people should be primarily responsible for what they post online, and that intermediary businesses need to come into the equation when, people are unreachable and in certain kind of circumstances like that. So I think we've got an opportunity here that's really exciting and important, and it would really be a key part of the puzzle in terms of creating a regulatory environment in Australia that's really conducive to the digital economy.
Thanks, Sunita. And I think you touched on a really interesting and important point there. A lot of the law reform, when you consider it, I think it does go back to questioning what are we prioritizing, or what is, the focus here? What are we actually trying to aim? What is the aim of this reform? Is it when you think about the need, your point that the individuals who are actually involved in making that defamatory or potentially defamatory comment should be the one responsible, but obviously in terms of just the complex nature of how how the internet works and how easily people can make comments online through the various all the various steps involved, it might just make it obviously causes some difficulties for the people whose reputation has been harmed to seek an appropriate avenue, which is, I'm sure, the reason why internet intermediaries are being involved and increasingly more involved in this process. So I might also throw the question to Daniel as well, whether you have any thoughts about whether the laws that are currently in place are sufficient, or whether we do actually need specific laws for the industry.
Look, thank you. I mean, I've really enjoyed hearing Christiane and Sunita's perspectives, and I agree that we probably do need to reconsider how our laws operate. But I think it is important to try to keep them simple as well. One of the issues is that the laws because they have a long and complex common law history, and then they've sort of been attempted to be reformed by the sort of introduction of statute and defences, those themselves are then interpreted, that has actually sort of, I think, added to uncertainty and complexity. But part of the issue is that this is an area that is very much a kind of law in context area. So, and that goes to Christiane's point about trying to be technology neutral, even if we're talking about, search engines or, for example, there might be some difference, or hyperlinks. It might be different, for example, to sort of say, well, look, hey, everybody, check out this hyperlink. It tells you all you need to know about person X if that hyperlink contains quite defamatory material versus, you know, a hyperlink that is produced by a search where the user's involved in actually trying to find that material. And so I think I would say that we need some change, but we need to keep the plaintiff's interests in mind and need to realize that also there aren't really many other areas of the law that do this kind of work for good or ill. And I guess I'm a bit of a fan of trying to work with the laws that we have to sort of tweak them. One of the issues here, though, is that a lot of the interpretation that we had was relating to traditional media contexts. And I think one of the exciting things is that more recent cases, like Voller and Defteros and Triculia and so on, have actually been more digital media or technology-focused cases. And so it may well be that whilst it's useful to have these reforms to clarify things, and I do think it may be, and it is in certain areas, that there is hopefully going to be a bit more of a convergence of positions between the sort of common law principles and some of the laws. And I think there is a danger if some of these reforms stray too far conceptually from what defamation law is about ultimately. So I would push back a little bit on sort of factoring in kind of the economic dimensions too much here, because traditionally defamation law is not very interested in that. It's really more about a balance between reputation and speech or communication in that sense. Not to say that from a policy perspective, those questions are not important, but certainly, you know, the traditional media's interest in, interests in terms of their economic power and so on, were never positively viewed as a reason to protect them from liability. So I do think there's some sort of danger there if there's overreach in terms of some of the proposals. But I think they're fairly carefully approached, and they're very hard issues. So I don't think there are easy answers, and I think there are problems with various aspects of the proposals. But I do think they're a step in the right direction.
Thank you. And just for context, for those in the audience who might not be aware of the amendments to the model defamation provisions. So the recommendations that that were made for the industry was a series of different recommendations, and industry stakeholders were invited to respond to which one that they would prefer and might be more appropriate. So the recommendation was that there would be a conditional statutory exemption for certain intermediaries, including ISPs, as well as those conducting standard search engine functions, which is what Daniel was talking about in the case of Google. As long as that there is no sort of external or monetary motivation for, I guess, highlighting certain hyperlinks, as well as two alternative options for other intermediaries, includes the safe harbor defense or an innocent dissemination defense, which I believe innocent dissemination is what is currently in place for a lot of the other secondary publishers, as it currently occurs in the more traditional forms of media. And just on that point, I'm sorry to throw this back at you, Daniel, but Sophie is no longer able to join us today. And so I guess from your perspective, were you saying that do you think that the model defamation amendment provisions are consistent or inconsistent with the legal principles of defamation law?
Well, it's interesting. The discussions that we've sort of had as part of the sort of stakeholder process have kind of, the last version that I attended, it looked like some of the people who are more skeptical about some of these changes were actually of the view that a lot of them, that the common law had caught up with Defteros, for example, in the most recent High Court case. So I do think, though, the first proposal around, I know people don't like technology-specific kind of laws and so on, but I do think it's quite helpful to have clarification that very passive forms or very passive style of actors like ISPs and so on, that they really should sort of be removed from the equation. I think the second aspect of the Google search dimension is probably captured by Defteros, but remember that the High Court are not in, there's a majority view that's supportive of that, but there's still some quite strong arguments the other way. I personally am a bit of a skeptic in relation to safe harbors because I worry about the plaintiff dimension and I worry about the loss of context and the loss of the kind of factual dimension. But in terms of certainty and clarity, they make a lot of sense. So I'm prepared to live with that one. I think it's probably quite a good idea overall, particularly now that Defteros heads in that direction. In terms of the two key kind of potential defenses, I mean, one of the things that's interesting, we're talking a lot about publication, but the elephant in the room in cases like Vola and Defteros and Triculia before was whether this older defense, which was really a policy-based defense at an earlier point in time, which I think in some ways these reform proposals are trying to kind of revisit, although the situation is more complex. So innocent dissemination was really about trying to soften the harshness of liability and how far that extended. So it used to extend to booksellers and newspaper vendors and so on, right? So I think now, in a sense, this 3A and 3B option is a way of kind of trying to think through that. So either you'd have a sort of safe harbor if you're able to kind of locate the originator in some ways, but the problem is the originator going to put their hand up and kind of want to be involved, I guess? Or you have what's styled as an innocent dissemination defense, but is actually a little bit different from, say, how the common law version of that defense or Section 32, the statutory variant, operates. Of the two, I'm a fan of 3B, which is closer to innocent dissemination. The problem is, I guess, with it, that potentially it might incentivize platforms to remove material. And so there's a censorship kind of problem or self-censorship kind of problem. And I don't like that very much. I'm a bit of a fan of maybe trying to adapt the original Section 32, innocent dissemination, by maybe making it a lot clearer there that some of these internet-related and tech-related actors are subordinate or secondary distributors who are the ones that are able to use innocent dissemination. But then maybe also trying to be more specific, because there's a non-exhaustive kind of list of the kinds of contexts that innocent dissemination might relate to. And I think that can be quite helpful. So that would certainly keep things simple and streamlined. The problem is, though, with defenses, is that they're dealt with at the back end. And so that's why I think the High Court is keen to kind of address some of these policy concerns through publication at the front end, because otherwise they might have a great defense, but they're still going to have to spend all the money, get the advice, live with all the anxiety and stress about how that defense is going to play out. And they might be sort of pressured into settling too. So I probably don't have a kind of silver bullet kind of answer, but I do think that this discussion and this process is a very helpful, useful one, but there are some issues with some of the proposals that need to be ironed out.
Yeah, thank you. And again, yeah, I think it goes back to that question of, what are we prioritizing here, and what is the balance that we need to strike between all of the various issues that come up as we struggle to come up with a law that fits, or that best fits. And I think it leads in nicely to the question that I had planned for all of our panelists. Are there potential consequences or implications that may arise from these model defamation provisions, whether that be positive or negative? And I might direct that firstly to you, Sunita.
Yeah, thank you, Sophia. It's a really important question. And I think, so this reform process has been going on for some time, and Digi has been engaging in it from the beginning. And one of my observations is that defamation law can actually be a really polarizing topic. So I think anyone who works with people who've had their reputation maligned will have a really strong view, and they want it to be as easy as possible to have content removed. I think anyone who has had their speech removed will also have a really strong view that they want to have more hurdles before their speech can be removed. And then intermediaries, and I work with intermediaries, will have visibility just into how challenging it is to balance both of those perspectives, and to sort of have this reluctant role as the arbiter in those sorts of disputes, and how you do that at scale. So I think in order to come up with a model that really works, you've got to put yourself in the shoes of each of those parties and really stress test the system. And I'll just also add on a personal note that I should have given the same caveat that Christiana did earlier, that I'm also not a lawyer, but one of my formative experiences with defamation was that prior to Digi, I used to head the global policy team at change.org. And so for those not familiar with that platform, it's a place where anybody can go start a petition on any issue. And there's amazing, wonderful petitions. But as you can imagine, when people have any number of grievances with different businesses, that's often an outlet for them to go and to take up, to write about those. And often if you're the business, small or large, on the receiving end of one of those petitions, your knee-jerk reaction when you see that content is, how do I make that go away? How do I stop that reputational damage? And then it's to contact the intermediary platform and to go the defamation route to have it removed. So, you know, having been in that intermediate role where you're trying to manage that issue, you know, often you'll look at a claim like that first through the rubric of bullying or harassment. And if it doesn't meet that threshold, then often, depending on where the jurisdiction is, you know, you might sort of say you need a court order. So I think what's interesting about the models that are being proposed in Australia is they're moving in a direction similar to what the UK has done, where they're taking that pressure out of the courts and coming up with a system that effectively enables the intermediary to connect the originator and the claimant. But as Daniel rightly pointed out, there are going to be circumstances where the originator doesn't want to provide their information. And I think this is one of the areas where the model might need to be a little bit stress tested. I mean, I will note that I'm very supportive of having these safe harbors. Our preference is actually 3A for those who are closely involved in the reform process. But I think we do need to look at those circumstances a little bit more, where when the originator says, no, I don't want to provide my details, or where the claim might not be legitimate. There might actually be another purpose where that person's trying to obtain information to potentially harass. There might be situations of domestic violence, all sorts of different contextual factors. You know, in the UK, in that situation, they actually have a process whereby the content originator can provide the intermediary with their contact details, and then the intermediary has to guard that unless they get a court order. And so we don't have that, and that's sort of this is the kind of circumstance that I think that the safe harbors need to look more closely at, around what happens, how can these systems be misused, and recognizing that there are just all sorts of really challenging different perspectives that need to be managed and balanced in trying to get the right outcome in this safe harbor.
Thanks, Anita. Christiane, did you have anything to add to that?
Thank you. Frankly, not too much. Our preference as Communications Alliance was also slightly for variation alternative A. The difficulties were nicely summarized before, again by Daniel. The difficulty will lie in all of them to balance that you don't make the intermediaries too much of an arbiter of the truth, which you do in all of them, versus limiting the burden on the court system, which is already enormous, and making it accessible also for people who don't have the financial means to bring big cases and to pursue them over years. And also ultimately, people also want their stuff removed, not over years. They want it removed immediately. So all of them have the same difficulty, basically. Ultimately, we favor A over B because we find it still focuses the dispute more between the complainant and the originator. If you ask me on the consequences, to go back to the question, I mean, I can nitpick now here a bit all on the consequences if we were to implement them as currently drafted. I'm not sure if that's the intention of the question. I mean, as currently drafted, I see a risk that, for example, search engines might limit their autocomplete function, because as currently drafted, that is gives them no exclusion from liability. But I mean, I think we all think that auto-completion is probably the best thing since sliced bread. So that's something that I would be a bit concerned about, and I think I would hope that that's maybe a drafting issue. Another thing that worries me a bit is both alternatives A and B talk to the process and the consequences of a complaints notice being given to the intermediary, but they don't make it a precondition for the plaintiff to initiate action against the intermediary. Again, I'm not sure if it's a drafting issue or if it's deliberate, but it would seem to me that a complaints notice should be a precondition before action can be initiated against the intermediary. So all these are little consequences of what would happen if it was implemented as drafted. One thing I think that is intentional at the moment, maybe, and that we should really pay attention to, is the additional powers given to the court to order removals from the intermediary. And as such, that is in principle, I think, a good idea. But again, we should pay attention that whatever powers are given there do not amount to something that resembles ongoing monitoring powers. By default or inadvertently, again, as currently drafted, that could be interpreted as such. It would cause legal friction with other acts, but it's also certainly, I don't think, in the spirit of the defamation law. So that is something that would worry us too.
Yeah, thank you, Christian. And I think you're right. I do remember a lot of these issues being raised during the roundtable discussions when the consultations were going on. And it seems like some may be drafting issues, but some may not be. So it'd be interesting to see like how where the next round and when the review finishes, what we end up with. I think John, you had you wanted to add something to this question as well.
Yeah, let me jump in and kind of give a different caveat. I am in fact an attorney, a lawyer, but I'm an American lawyer, so I would not presume to kind of debate the history or nuances of Australian law, but I do want to kind of offer a kind of a different perspective, and I actually kind of want to go back a little bit to the very first question of, is it good to have an internet-specific law or not? I mean, in the United States, not to suggest that the United States' approach is the only way to go, but the United States has basically a general purpose defamation law, and we have a separate general purpose intermediary protection law. That's something that restricts liability for intermediaries. And what's particularly striking about the Australian proposal, comparing it to the American law, which is called Section 230, is that the relevant part of Section 230 fits in about half of a page. And the proposal here that Australia is looking at is kind of 9 solid pages of text. And I actually think those 9 solid pages introduce a whole lot of potential pitfalls. I mean, Christian has already identified the autofill challenge. That's a relatively small thing, but I would also read this to prevent prevent, say, a CDN, content distribution network, to also provide cybersecurity screening. In other words, the drafting here suggests that if they provide any services other than just being the conduit, well, then they lose their protection. Again, maybe that's just a drafting problem, but I actually really strongly believe that there's no way that the legislators or the judges can identify all the different technical business models and technical models that are in play on the internet and not kind of essentially inadvertently prohibit certain models. So I actually think there's significant risk. I also think that the structure of both choice A and B seems to very, very readily default to having the intermediary disclose the true identity of the original poster of the content. And maybe that's a good thing, but certainly I think that a Chinese dissident who is now living in Australia but wanting to critique the Chinese government, I think would be a significant risk if they posted anonymously. And then the Chinese government could easily claim, oh, this is defamatory. And at the end of the day, that dissident will get outed. And I think that would cause significant risk. I mean, in the United States, the outing, the unmasking of the actual speaker, basically, generally speaking, can't really happen short of a court order. And as I read both A and B, the unmasking can just simply happen because that's the cheapest thing for the service provider to do. And then let me just kind of pass on one other broad comment and reaction, partly reacting to the 9 pages of text. And this is 9 pages of text that just relates to defamation law. I haven't seen the 9 pages of text that relates to other content issues and intermediary responsibility. So to me, the complexity that Australia seems to be on a path down, that will have one very powerful effect. And that is that the only people who will have the lawyers and the staff and the resources to follow these many, many pages of very detailed law are the major platforms, the existing major platforms. And so I think Australia is, on a path toward making, upstart competitors have a much higher, barrier to entry to kind of get in, because instead of hiring engineers to make a product, they're going to have to hire lawyers to read through all this stuff. So, I mean, obviously I have a kind of a bias for the much simpler approach that that we use in the United States, and that obviously is not perfect at all either. But I do have these concerns. So I just glad to kind of put them out there and play devil's advocate from across the pond.
No, thank you so much for those insights. And I think you do touch on a lot of issues that I know industry is concerned about, which is the rise of legislation or regulation of the of telecommunications and the sector, especially in recent times, which is something that we have heard about during the NetThing sessions earlier in yesterday, and some of the sessions today touched on that slightly as well. And so it is a critical point, and I think it does go back to that question of if you have, do you have a broader legislation which might capture too many and place burdens on all of these different all of the different specific sections of the sector, or do you have these very detailed legislation which might go too far, as you put it? I am concerned that we have actually hit the time limit. I do see that we did actually have a question from John Lawrence about any thoughts on the Gonzalez and Google case that's going on before the United States. So if someone had any thoughts on that, just to quickly wrap that up, and then we might have to wrap up the session.
It's a longer conversation than we can have in the brief time we have, but you know, it is going to be a very interesting case because it in fact is the first case to go to the Supreme Court that really is getting into some of the issues that you in Australia are wrestling with right now. And so you know, I certainly am following it closely. My organization, Internet Society, is looking at it very closely and may participate in the case. So you know, other than to acknowledge it's certainly very relevant to this conversation. I'm not sure we have time to get into it further.
Yes, I understand. Did anyone else have any closing thoughts or comments that they wanted to make?
No, I just want to comment the Online Safety Act maybe to John for further study.
Yes, I was going to mention that as well, and also to say that one of the things that's quite surprising about the court's recent decisions in Defamation and Vola is that there actually seems to be, particularly from Justice Gageler, a kind of interest in a more kind of transnational, harmonized common law approach, which is surprising. And the judges themselves are willing to kind of look away from the fact that we don't have a Bill of Rights or formal constitutional protection in a positive sense for free speech. And that's probably quite an interesting thing. They rely very much, for example, on a Canadian decision of Crooks and Newton, and also on some New York decisions in coming to their decisions. So I think hopefully there's a bit of a shift in that regard, and we can sort of, I do think harmonization is an important aspect here, given the kind of transnational dimension of the problem.
Yeah, thank you. So as I said, we are at time, and I'm also aware and considerate of the fact that John is joining us from a very different conflicting time zone, and that Christian also, I'm sure, would like to get some rest. And so now that the consultation for the amendment to the model defamation provisions is now over, but I'm sure that I don't think the discussion is over, and I'm sure that these same issues will continue to arise as people continue to use the internet to make some, sometimes very legitimate, sometimes very unlegitimate, unsavory comments online. And also in areas outside of defamation as well, which is something that I did want to get to, but unfortunately I don't think we'll have the time to get into it at length, where internet intermediaries might become responsible and liable for what sort of activity occurs online at the content layer. So it'll be a very interesting space to watch. But I want to thank all of our each of our panelists for their insights and how we might manage an appropriate balance. And I want to thank NetThing for this opportunity, as well as to everyone the NetThing community who attended. And I'll hand over to Bronwyn.
Thanks so much, Sophia, and great job organising such an interesting session, and what a great way to close out this year's NetThing. So we've